Hey everyone, it's Rob Ryder. It's 31st of January 2013, and it's a glorious day. Because today we're going to look at the Praecipe Act of a King, and it's behind the curtain. I'm Rob Ryder, and my email address is courtofrecord@aol.com. This is really what they don't want you to know. Let's go see what it is. So, medieval Latin, Praecipe, legal writ commanding a person to do something or show cause why he or she should not. Commanding, it's a writ that commands. It's a writ under the Great Seal from the Court of Chancery. We've been trying to find a written request for an action as the issuing of a writ of execution from a party to a clerk of courts or sometimes to a judge, filed for a writ of scire facie, shall issue upon the plaintiff. Note, when addressed to a clerk, a praecipe is usually a request for some action that does not require immediate judicial review, such as the issuing of a subpoena or preparing of a record for appellate review. When addressed to the judge, as for a jury instructions in some jurisdictions, a praecipe is similar to a motion. However, a praecipe originally was a writ issued by the king to a sheriff, telling the sheriff to command someone to do something, as to release land being withheld from another. So, back in jolly old England, the sheriff isn't the tin star we know now. The sheriff was the king's top businessman in a district, shire, county, call it what you will, some defined territorial land. Sheriff of Nottingham. However big Nottingham was, there was a sheriff. Well, there was a sheriff of someplace else and a sheriff of someplace else. Now, what Blackstone says is these people don't hold their office for more than 1 year at a time. And they're the king's top businessman, and so, it's not the 10-star sheriff you see walking around. It's a judge with a seal. Because he seals all the documents that have to do with the business of the shire. Now, it could be it's the clerk of the court, as far as that goes. What Roe found out is where her clerk of the court business building is, that building actually has two addresses, like 340 and 339, let's say. And building 340 has a license to do business in the city, but building 339 does not. Well, 340 is where the clerk of the court's office is, and I think in the other side is where the courts are, the actual courts. So, interesting stuff about the clerk of the court, who, their oath is held by the bishop. They are the chancery, and they answer the chancellor. So it's the Court of Chancery, and in England you would go to the Court of Chancery to get a writ to sue out an original writ under the Great Seal from the Court of Chancery to prosecute a case or to, plea your case. But continue on. A praecipe in Latin means to command. It's not a request, it's a command. Writ issued by a king to a sheriff. That would be like a pleas of the crown. It's a complaint upon which the king is a plaintiff, which ends up with an order. And we're just giving orders now to the sheriff. Praecipe is a written motion or request seeking some court action, especially a trial setting or an entry of a judgment. At common law was a writ ordering a defendant to do some act or to explain why an action was inappropriate. Praecipes are governed by federal, state, local laws which vary by area. The following is an example of a state statute dealing with praecipes. I don't know what state this is. This all came out of Wikipedia. But it says, writ to issue a praecipe. Writ to issue on praecipe. So the praecipe is the request. The writ is what the Court of Chancery is going to produce. All writs and orders for provisional remedies and processes of every kind shall be issued by the clerk of the court of common pleas, but before they are issued, a praecipe shall be filed with the clerk demanding the same. So all writs and orders of provisional remedies. Well, what's a provisional remedy? Uh, Preservation of the status quo until final disposition of a matter can occur. And what's status quo? The meaning of the current or existing state of affairs is commonly used is a commonly used form of the original Latin statu quo. Literally, the state in which to maintain the status quo is to keep things the way they are presently are. The related phrase status quo ante, literally the state in which before, means the state of affairs that existed previously. The original phrase from 14th century diplomatic Latin was in statu quo res erant, ante bellum, meaning in the state in which things were before the war. We're going to go back to the way things were before the war. What war are we talking about? The war of good and evil. We're just going to go back to good. This gave rise to the shorter form, and the state of which was before war, indicating the withdrawal of enemy troops and restoration of power to the pre-war leadership. That would be us. We are the kings. And if we're at war and there's a military here, we're going to go send them away. We're going back to the pre-war leadership, where you are your own sovereign. In the United States, a praecipe is a document that either A, commands a defendant to appear and show cause why an act or thing should not be done. So you can use it to summons a defendant to appear, or request the clerk of court to issue a writ and to specify its contents. So you go to the way it would have worked in Old England was you went to the Court of Chancery and you told them what your problem was, and they would write you up a writ to satisfy the needs of your problem, and then you could go take it to the Court of Common Pleas in Chancery, in the Chancery side, to determine rights, title, and interest to property, or for a money damage or whatever it was. But all the original writs came out of Chancery for everything. If it was going to the Court of Common Pleas, if it was going to the Court of Exchequer, if it was going to the King's Bench, you had to have an original writ under the Great Seal sued out of the Court of Chancery. So in Canada, it is used in place of a notice of motion as an application for a desk order that is granted in the court registry without a hearing before a judge. You can get these writs without a hearing before a judge. However, in the United States, clerks are variously limited to handle such precepts, typically status adjustments. Adjust your status. I am not a U.S. citizen. I'm a national. In the name of the court, a clerk cannot issue forceful or mandamus writ. Now it says the United States clerks. It didn't say the state clerks. It just said the United States clerks. I'm going to say it's at the federal level. In the territory, it ain't quite the same, and we're here in the territory. If you're not in one of the organized 50 states, you don't have to be. It's just the state of Michigan is a defined territory of land. Underneath that lies the Republic of Michigan, or the Territory of Michigan, which was there first, and that's where they put the townships in. And the townships, in Thomas Jefferson's idea, would be the elemental republics. Each one would be its own republic. But it says United States clerks can. I don't know if the state clerks can or not. We're going to find out. The word praecipe is based in Latin. The word survived long after the Roman Empire and found its way in England, where it survived in English law. So it's part of English law. The writ was often issued to amend or change a subsequent order or to correct an error that had been missed earlier. Its appearance in American law is not surprising, as many of the English customs and traditions were passed on. Today its functions has barely changed since those days of Roman times, and it was issued to amend or change a subsequent order or to correct an error. That's some of the things it was used for. These rules like this, when you see them, these are out of Pennsylvania. So if you just Google Pennsylvania Rule 1037, you would find judgment upon default or admission assessment of damages. If an action is not commenced by a complaint, the clerk of the court, civil side, pro the notary, upon praecipe of the defendant, shall enter a rule upon the plaintiff to file a complaint. If the complaint is not filed within 20 days after service of the rule, the pro the notary, upon praecipe of the defendant, shall enter a judgment of non-pros. And that's the name of a judgment rendered against the plaintiff for neglecting to prosecute his suit agreeably to law and the rules of the court. This goes back to what we've been trying to do last month or so, is say, hey, they haven't signed the complaint in a foreclosure. The plaintiff hasn't signed it. His attorney of fact has, maybe, but it doesn't matter. It's not his complaint. The plaintiff must sign his complaint. And a few videos back, it was Bob in Massachusetts who gets a ruling from a judge that is telling GMAC to submit another mortgagee's affidavit, although there already is one in the case called a mortgagee's affidavit that GMAC has signed, but they've signed under oath that they're the servicer. And now the judge wants them to put in one that says they're the mortgagee, and they haven't done it yet. So that's just the point is, we're just pointing out that the plaintiff hadn't signed their complaint. Now, that isn't what the judge ruled on, because he can only rule on something else, but because of the way the complaint was written, or the answer to what we were doing was we were answering the complaint in a civil case. And so Bob put in an answer. Now, it didn't cost him anything to put that answer in, but then Bobby in Arizona went to answer a complaint, and so did Roe, and in both cases they had to pay to put their answers in. And I said, that doesn't sound right. It's like there's two different cases going on. And more on that stuff later, but at the end of the day, if you just go down and you put a praecipe in any case, it doesn't matter if it's a foreclosure, traffic, criminal, whatever, into the case that says that the plaintiff hasn't filed a complaint yet, and that's all it has to say, and if they don't file it in 20 days, the clerk of the court, upon you putting in another praecipe, shall enter a judgment for non-pros, not prosecuting the case. So in other words, a default judgment. And you put this in with the clerk of the court, and it's just called a praecipe, and we'll look at some shortly to show you how simple they are. And so you put it in and you just say the plaintiff didn't sign the complaint. Okay, so another rule from Pennsylvania, 237, which requires the praecipe for judgment of non-pros to contain a certification of written notice of the intent to file a praecipe. So, it takes some kind of certificate of written notice. So there's also notice that goes on. All right. Also says the pro the notary on praecipe of the plaintiff. Now this is the plaintiff can put these in too, and this is what they're doing. These praecipes are what end up being in a foreclosure a writ of execution to the sheriff. So they're using praecipes against us, and this one I'm talking about the stuff happening behind the curtain. It isn't really that court case you're looking at. There's something going on in the background, and it's being done with these praecipes. So, shall enter a judgment against the defendant for failure to file within the required time a pleading to a complaint. All right, so first of all, they may not have put in a complaint. That's what this one says. But even after they have put in a complaint, well, you can file your pleading, your counterclaim, your defense, whatever it is, to the complaint, which contains a notice to defend or except as provided in subdivision D for the relief admitted to be due by the defendant's pleadings. And of course, if they make a complaint and you don't plead into the correct court with a praecipe, well, then the ruling is going to be that you didn't answer the complaint, therefore you agree with it. So there will be a complaint in there, except it won't have been signed by the plaintiff. And if you don't complain about that being signed by the plaintiff, then that complaint will stand, and it will be assumed that you agreed with the complaint. And again, this is happening with praecipes. 237.1, which requires the praecipe for default judgment to contain a certificate of written notice of intent to file the praecipe. Now, I think that's what the lis pendens is, and the notice that we see is the notice of lis pendens, and the lis pendens is the praecipe they're using. Lis pendences are used in some foreclosures, and foreclosures are really mechanics liens. Believe it or not, just some kind of lien for not paying some kind of debt. And it could be for the $10 that it shows on most warranty deeds, that for $10 in hand paid and other valuable consideration, it's for $10. That's what hasn't been paid. Okay, Rule 3031, again from Pennsylvania, judgment upon default or admission, assessment of damages. The pro notary on praecipe of the plaintiff shall enter a judgment against the defendant or terra tenant for failure within the required time to plead to the writ, or for any relief admitted to be due by the defendant or terra tenant's pleading. The pro notary shall assess damages as directed in the praecipe for judgment. So what we need to be asking for are, have there been any praecipes been put in against me in this case? Because they don't put them in the court file. These are in the clerk's file. You know, they're just not putting them in the court file. But, you know, the notice of lis pendens isn't the lis pendens, but the notice means there is a lis pendens someplace, so where is it at? And what's a terra tenant? This is interesting. One who has actual possession of the land. And at first blush, you would say that's you. But wait, there's more. Possession. The ownership, control, and occupancy of a thing, most frequently land or personal property by a person. The ownership, control, or occupancy, right? Has lots of different, you can be the owner, you could control it, which means you're not the owner, you're just controlling it, or you're occupying it. And the U.S. Supreme Court has said there is no word more ambiguous in its meaning than possession. Duh. The idea of possession is old as the related concepts of private property and ownership. Our modern possession laws originated from the ancient Roman doctrine of English natural law, inherited most of the Roman possession ideas, and later the British brought their law of possession into American colonies. Following the War of Independence, state federal courts continued to use and expand upon the historical notion of possession. They kept broadening the definition of what possession meant. Possession versus ownership. Although the two terms are often confused, possession is not the same as ownership. No legal rule states that possession is 9/10 of the law, but this phrase is often used to suggest that someone who possesses an object is most likely its owner. Likewise, people often speak of things they own, such as clothes, dishes, and their possessions. Okay, someone who possesses an object is most likely its owner. He who holds a legal title is the owner. He's in possession of the legal title to the land, whoever he is. Right now, he isn't you. Somebody else has got the damn legal title. And that's what we're trying to get back. However, the owner of an object may not always possess the object. For example, the owner of a car could lend it to someone else to drive. We're the ones that made them a loan. We loaned them the legal title. Not only to that land, but same with our body, same with our personal property. In the all capital letter name estate, we've given them the entire estate as a gift on a unilateral contract. But this is going to help us get that back. But let's look at this. Now, this is in Pennsylvania also, actions and mechanics liens. Rule 1659, compelling commencement of action. If a claimant has filed a claim and does not file a complaint, the protonotary, upon praecipe of the owner, shall enter a rule as of course upon the claimant to file complaint within 20 days after service of the rule, or the forever be barred from doing so. So when you go and put this in, who's ever brought the claim against you has 20 days to put it in, or they will be forever barred from doing so. That's why you can't be charged with the same crime twice. If they bring a crime against you and you put a praecipe into the case and they don't produce the complaint in 20 days, they will be barred from ever doing so. We just need to go put praecipes into the cases they have against us. Now that's all defensive. We're going to figure out how to use it offensively, but I'm telling you right now, any kind of case somebody has going, tax, whatever, go put a frickin' praecipe in and ask them to produce the frickin' complaint. They got 20 days. They can't do it, it's over. If the claimant fails to do so, the protonotary, upon praecipe of the owner and proof of service, shall enter a judgment for the defendant. You'll get a default judgment. And this talks about how they can be served. Service of legal papers other than original process. And see, I don't think this is an original process. This is a provincial process of some kind. Because this says copies of all legal papers other than original process filed in an action or served upon any party to the action shall be served upon every other party to the action. Service shall be made. Basically, everybody has to be served. But this is how easy it is. By handling or mailing a copy or leaving a copy for the party at the address of the party's attorney of record, endorsed on the appearance, or prior pleading to the party, or at such other address as the party may agree. Such other addresses as a party may agree might include the mailbox in the protonotary's office. And what Rose said was when she went to the door that said Circuit Court above it, walked in, and it was basically the Chancery office, she noticed that all these attorney firms have mailboxes in there. Isn't that interesting? And so when you put this praecipe in, the clerk's going to turn around and serve the attorney of record by putting it in his mailbox. And they've been served. And 20 days later, they better have an answer in. Or they're going to be non-suited, and a default judgment in your favor will be rendered. And from that default judgment, an order for them to return the property, and after the order to return the property, a writ of execution to the sheriff. Along those lines, what people are trying now, we just need to be doing it with the clerk's office. This is no different than notary presentments and all these other things you're trying. It's just using the right frickin' notary, the damn clerk of the court, whose oath is held by the bishop. And these are original writs under the seal of out of Chancery. And to defy the court of Chancery will bring the thunderous wrath of the Vatican upon you. Now, do you want to use the notary down at the frickin' UPS store, or somebody who's got the Vatican behind them? I'm going to go with B. They could just transmit a copy by facsimile. Boom, hey, you've been served. Very simple to serve. And again, I'm not going to read all this, but this is Pennsylvania Rule 440, right? If you want to know how you serve these papers, that's how that's done. Rule 236, providing for the pro notary to give notice, orders, of judgment, also matters of face mail or other electronic means. May give notice required by subdivision A or notice of other matters by fast mail transmission or other electronic means if a party to whom the notice is to be given or the party's attorney has filed a written request for such method or notification or has included a fast mail or other electronic address on the prior legal paper filed in the action. So when the foreclosing attorney firm came in to open this case, they've already put all this paperwork in place that if we come in with our correct paperwork, the system will take care of itself. They've already self-confessed. Return of service. So now the next thing is the return of service. When service of original process has been made by a sheriff or other person making service, shall make a return. So the other person is going to be the clerk. If service has not been made and the writ has not been reissued or the complaint reinstated, a return of no service shall be made on the expiration period allowed for the service. Okay, so this just has to do with how it's served, right? My point is they're going to do all this stuff for you. So let's look at what some of these look like. Come on. All right. Just a second. All right, so this one is a praecipe for a subpoena. Plaintiff, defendant, case number, to clerk of said court, please issue subpoena for name of witnesses and addresses to appear as witnesses on behalf of boom. Attorney or pro se name, a pro se signature, right? This is how easy it is to put in for a subpoena. You fill this out, give it to the clerk, and the clerk's going to issue them. Sorry about this. Virginia, in the Circuit Court of Fairfax County. Plaintiff, defendant, case number, serve. Now the interesting thing says this has Friday motion days for praecipe and notices. So if there's a praecipe that has to go to the judge, because some of them need to have a judge's seal on it. Some the clerk can do, some the judge has to do. To get equitable remedy, it has to go before a judge. All the judge can do is put a seal on it. You're putting a motion in for it. Boom, if it's good, then and the clerk's already taken it, he's going to put a seal on it. To me, that's just going to be a formality. That's some kind of lien act. See, so Commercial Real Estate Broker Lien Act. Here's how they could put a lien against your property. If everything is considered commercial, then your residence where you live is considered a business. So there's a Commercial Real Estate Broker Lien Act. They can put a lien against commercial real estate. Yeah, I know they call it residential. Here's one for Nebraska. Praecipe for personal service. To the clerk of said court, please direct the sheriff of some county to serve a copy of the order to show cause upon whomever. So we can put in an order to show cause why somebody shouldn't be arrested for impersonating an officer. Right? Did that cop that stop you, did he have an oath of office? Well, they're going to have to come in and show cause. Bring your oath in. If you don't, then the order is going to be that you're arrested. Something like that. We'll work those out. That's what I'm saying. It's just that it can be used not only for defense, that this is how we're going to get our property back. Our all capital letter name estate, the whole thing. This is in Allegheny. Praecipe for judgment for non-pros, right? So here you go. To the Director of the Department of Court Records Civil Family Division. Kindly enter a judgment of non-pros against the plaintiff in the above entitled case for failure to file a complaint within 20 days and serve a rule issued pursuant to pro number, whatever it is. Right, so I think that's going to be the default judgment. Some additional space. So this is the one you use to get the judgment after they haven't responded to you telling them to put a complaint in. And if there's something in there that has the attorney of record signature, I'm sorry, it's not going to make it. The plaintiff must sign his complaint. And if it's the bank, that would be an officer of the bank. Here's another one. Praecipe for judgment of non-pros. So, if you check your state, you're going to have praecipes. Now, Ro went down today. We talked about this, and she had to go to the circuit court anyways. And she wanted to have, just give me a copy of every kind of form you have. And the lady took her, well, I can show you all the forms you have on a screen. And so Rose said, well, what about praecipes? And she said, oh, well, all of them but those. They don't show up on the screen. So we're going to see what they have to give. Praecipe and rule to file a complaint. Issue rule on somebody to file a complaint in the above case within 20 days after service of the rule again. Right? This is how simple these praecipes is. This is all Bob in Pennsylvania. This is all you got to put in. Whatever yours is going to look like. A praecipe and rule to file a complaint. Issue rule on whoever the plaintiff is, the bank, to file a complaint in the above case within 20 days after service of the rule of or the pro notary upon praecipe shall enter a judgment of non-pros. Default judgment against the plaintiff. And if you watch a couple of videos back where I'm going through Bob's case, right, this is the one where the judge, he just adjourned the case. But he had said during the hearing to Bob, you really are more interested in form or substance over form, aren't you? And Bob said, yes, he was. And the judge left these big holes in the case. He adjourned the case. He handed down orders. He did all these things. And really, it's what led me to looking at this stuff is what he did. And I want to thank him very much. Praecipe for writ of summons. Issue a writ of summons in the above case. A writ of summons shall be issued forwarded to attorney sheriff. Okay, so we can issue summonses. Summons them to court. For what? Well, to answer what you're going to have for a complaint. A praecipe for writ of certoria. I can't remember what certoria was exactly. Oh, yes, I do. Where is that at? Well, we're almost there anyway, so let's go back to this real quick. So those are just different kinds. Okay? Now, I love this rule. This is how we get our property back and make big changes. Pennsylvania, Rule 235, notice to Attorney General, constitutionally or of statute, charitable bequest or trust. In any proceeding in a court subject to these rules in which an act of assembly is alleged to be unconstitutional, or charitable bequest, which is a unilateral contract which only you have signed and you've given to them, and it's an imperfect gift until you say different, it's a charitable bequest. Or it's a trust, lowercase trust, which is here, I trust you with my entire estate, and you don't need to give me anything to show that we have an agreement. That, when I come back, you're going to give it to me. Nope, they didn't do that. They didn't sign the agreement. There are no trusts. There are no trustees. or at least you didn't appoint any trustees, because anything that you sign and give to them, they don't sign it and give it back to you. Everything only has your signature. All unilateral contracts, all are imperfect gifts, and they will not be enforced in chancery. But what would an unconstitutional act look like? Well, funny you should ask. I'm going to show you one. This is in Michigan, Local Government School District Physical Accountability Act. And this act says, rectifying a financial emergency of a local government which is in receivership. And basically, the people are the local government. And this is what allows them to put you into put the local government, the people, into Chapter 11 bankruptcy. And the funny thing is that, it says that school districts can be the local government. Interesting. This section empowers a local government of which an emergency manager has been appointed, and the emergency manager is the city manager, has been appointed to become a debtor under Title 11. So here's an act that just allowed one man to put everybody else as a debtor under Title 11. Here's another great one, the Home Rule City Act. This is the act that in this one says, in Michigan Compiled Law 117.36a, Section 6, which is statutory lien and trust paramount and superior to all other liens, interest of any kind. This is going to put a lien, the lien and trust created under this section for the benefit of bondholders or others is perfected without delivery, recording, or notice. Well, guess what? That's unconstitutional. King versus Mullins, 171 U.S. 404, which says that a lien that is not delivered, not recorded, or noticed is unconstitutional. It's also called a statutory lien. And so, yes, I may know of a public act, Home Rule City Act, Act 279 of 1909, that's unconstitutional. So what am I supposed to do? Well, and the Commonwealth is not a party. The party raising the question of constitutionality, or the plaintiff in a proceeding involving a charitable bequest or trust shall promptly give notice therefore by registered mail to the Attorney General of Pennsylvania, together with a copy of the pleading and other portion of the record raising the issue, and shall file proof of giving of the notice. The Attorney General may intervene as a party, or may be heard without the necessity of intervention. The court, in its discretion, may stay the proceeding pending the giving of the notices and reasonable opportunity to the Attorney General to respond thereto. If the circumstances of the cause require, the court may proceed without prior notice, in which event notice shall be given as soon as possible. Or the court may proceed without waiting on actions of the Attorney General if in response to a notice. So basically the court can do whatever the hell they want to. This is like doing the quo warranto. By what authority are they doing whatever they're doing? It's unconstitutional. By what authority is my all capital name landed estate being withheld from me? I'm the owner. I want possession, ownership, control. I want absolute ownership. I am the owner. I want the legal and equitable title. I want it when I write my signature. It's for my benefit, not for somebody else's. We live in a credit system. There is no money. Gold has no value. Silver has no value. It's all what you think it's worth. Well, in this system, your signature is what has the value. And somebody else controls it because they have the legal title to your landed estate, because you signed a piece of paper and gave it to them as an imperfect gift. And we're going to go get it back because I didn't mean it to be a gift. And so you take it to the Attorney General. And it makes a lot of sense. It would be the Attorney General it goes to. Um, that's who the king would go to with his information, to the Attorney General. And the Attorney General would handle business for him. Ceratoria. A type of writ seeking judicial review, recognize the U.S. Roman, English, Philippine, and other law, meaning an order by a higher court directing a lower court, tribunal, or public authority to send the record in a given case for review. If you want to get your birth records, you put in a praecipe asking for a writ of ceratoria, actually ordering a writ of ceratoria, to direct the public authorities to bring the records in. Right? It's not some private person holding them. People who have wanted to get their original birth records have been told by county clerks before, well, that's going to take a court order. This is how you get it. This is how we get to examine the records. It's a beautiful day. So, as we keep going until this all gets worked out, I could really use some help on keeping the lights on. If you can donate, please do. There's my address, my daughter's PayPal account, and if you just want to email me, courtofrecord@AOL.com. So, this is big stuff. It's really fresh to me. I only came across this like 6 o'clock this morning. I at least put it together in my head what it was actually saying. And we want to do these praecipes. And it's not a court case. They've already opened a case. They haven't signed the complaint. The IRS hasn't signed the complaint. The FBI hasn't signed the complaint. The attorney, the state of Michigan hasn't signed the complaint. The United States of America hasn't signed the complaint. Nobody has signed the complaint. So put a praecipe in saying you got 20 days to sign the complaint. If you don't, they're non-suited and can never bring it again. This is so huge, people. I hope you're catching on to that, and watch what happens the next few weeks. It ought to be pretty interesting. So cool. I'll leave it at that, and stay tuned for more. We'll see ya.